Fired Up is presented in audio format wherever you listen to podcasts and in video format on YouTube. Wherever you tune in, please remember to rate and subscribe to the show. Thank you. D. Scott Crook is the Utah employment lawyer. Fired Up focuses on questions that he frequently receives from his professional and executive clients regarding severance, employee stock option agreements, executive employment contracts, and more. A quick disclaimer, Scott is licensed only in Utah and Idaho. As with any discussion about the law, the information on this podcast generally describes the law and is not intended as specific legal advice. As I'm sure you know, laws frequently change and can be different in different jurisdictions. So please consult with a lawyer if you have specific questions about your situation. All right, welcome back to Fired Up. And today we are very fired up, aren't we, Scott?
We are. I'm always fired up.
Always.
Always.
Especially because today I've been excited about this episode because we're going to look at a real but redacted severance negotiation letter. Is that correct?
Well, I would call it an attempt at getting some kind of severance from a disgruntled employee.
Okay. So if you are out there and disgruntled, wait. Step away from your keyboard and watch or listen. This would be a good one for you to watch because we're going to be doing the screen share. So if you're listening, just remember we are on YouTube under Fired Up. So, Scott, go ahead and share your screen and you just tell us what makes this such a bad letter.
Well, I'm going to go ahead and before I actually share the screen, let me tell you a couple of things. One, you have to remember, and we've talked about this before, so this is something that probably you're tired of hearing, but maybe others haven't heard it yet. But you are not entitled to severance in Utah except in 3 limited circumstances. And those 3 circumstances, generally, you'll know if you're entitled to severance. And so you should always remember, before you start to negotiate anything, if you're not entitled to it, you don't have leverage. And the only way you have leverage is if there is something that creates a problem for the employer. And so what you have to remember is that the world is not based on TV scripts or movie scripts for that matter, and that people aren't going to be scared of you just because you sound hostile. So now, with having said that, let me go ahead and share my screen.
All right.
So, sorry, it takes me a little bit to see what I needed to see. Okay.
All right.
So just to give you a little background, I not only represent executives, but I also represent a lot of employers. And in my role as advising employers, I often am brought in when there's an employee issue and the HR department either has questions or they don't want to deal with the problem because it's gotten, for lack of a better word, hot enough, where they're just trying to make sure that they're not going to say anything that's going to endanger or harm their position with respect to the employee. So this is an example that's been, I hope, sufficiently redacted of an actual letter that one of my clients received from an employee who was let go.
Okay, so this is a letter that one of your business clients received from a employee that was
was let go. Okay. And the circumstances of this employee's termination was such that she had violated a few rules and had actually been a bit insubordinate. And so the employer decided that the behavior was bad enough that the employee should be terminated. Now, so this wasn't like a layoff, and we've talked about this is actually a situation where there was, for lack of a better word, a good reason to let go, to let somebody go. So it was a termination, and it wasn't because of financial reasons. It was because there was a problem, right? So, one thing to note about this is, even in those circumstances, sometimes asking for severance is okay, because in those circumstances, sometimes you're let go, and you're let go for an illegal reason. And so sometimes you go to an employer and say, hey, well, give me severance, or give me as part of a settlement, give me a severance, and I'll stop bothering you and I won't sue you. So that's the context of this letter. Okay, so first of all, they write the letter to the HR manager.
Sure. So I'll read for our listening audience. Do you want me to just start at the Dear HR Manager?
Yeah, go ahead.
Dear HR Manager. Okay.
Okay. Keep going.
I am writing this letter to dispute my termination of employment with employer department on Tuesday, March 9th, 2021.
Okay, so there's obviously not so much
to analyze.
There's nothing about that that's bad. I mean,
okay.
And ordinarily, if you get that, you're just saying, oh, well, they want their job back. Well, in this particular case, this employee ends, and I'm going to go to the end. It's unfortunate that a separation between employer and myself has happened, and I look forward to hearing back from you by March 26, 2021 with an acceptable severance offer. If you do not respond, I will seek counsel to determine what further steps I may wish to take. Okay, so we know that the intention of this letter was for this employee to ask for severance.
Right.
Not to get the employee's job back, not to say, well, I want this person fired who fired me. It was to get severance. Okay, so there's nothing particularly bad in the next two paragraphs. One talks about they've been employed there for 19 years, and they claim that they've displayed professionalism with their interactions.
Displayed professionalism with my daily interactions with customers, coworkers, and supervisors.
And then, the next paragraph goes on to describe how they received the Employee of the Month award twice. I remember this was in 2021 that the letter came. So once was in 2015, so 6 years before, and 2017, which was 4 years before, which, by the way, is not particularly persuasive. Because, well, as everyone knows,
I know our audience for this podcast is employees, so yeah. But there's 12 months in a year, and yeah, that's twice out of.
Yeah, I mean,
they could have said like 1% of the time. But
or
anyway,
the other thing is that this was 4 years ago, right? And a lot happens in 4 years. Just because you're Employee of the Month 6 years ago doesn't mean you didn't do anything wrong yesterday, right? So,
right.
But it is an intention to show, hey, I've tried to do my job. And then goes on to say, I've also basically gone above and beyond by doing things that were not even in my job title. And read that sentence, if you will, James, because I think this is instructive.
Okay. I have exhibited dedication by performing job functions beyond my job title, including janitorial duties, program coordinator duties, and other executive duties with no extra compensation offered or received.
So one presumes that if they had been offered, they would have been received. But beyond that, the interesting thing about this is, while this was intended to an employer, this is intended to say, well, I went above and beyond. This actually turns off a lot of employers, because basically what you're saying is, it's not in my job description and I did it anyway. You should feel lucky. I mean, right. That's not a persuasive thing to do, because most employers, while they appreciate that you have done extra work, saying that I did more than my job description required seems petulant, actually. And it seems, and not that people aren't entitled to receive, to have job descriptions, right. But to say, well, I did a lot more than the job description said I should, it's not a great way to win friends and influence people, I guess. It's the way to say that.
No, and also most job descriptions have a bullet point in there that say anything else we say you have to do, you should do. Just as someone who's seen a lot of job descriptions.
And I'm purposely not saying what the job was, because I think it could be, somebody could infer what it is. But let me tell you that janitorial duties, program coordinator duties, and other executive duties were something you would expect in that position to be done. So it's not particularly persuasive. Certainly they weren't a janitor, but their role required them to sometimes pick up after other people. So it's not particularly persuasive. Then the next paragraph says, this person has stayed late. This person has helped their coworkers. And now we get to some stuff that really starts to be a problem.
Okay.
If you want to read read the as stated in the termination.
Sure. As stated in the termination letter, I am being accused of retaliation against coworkers. Retaliation goes both ways, and on more than one occasion, I too have received harassment by coworkers. When these incidents occurred, I went to my supervisor, HR department, and other executives to voice my concerns, and walked away feeling that my voice was unheard and I had no presence.
Okay, so why this is a problem is that the person is essentially almost conceding that she'd been retaliated against. I'm sorry, that she had retaliated against other people, right? Yeah. And that, well, it's just a tit for tat environment. The worst thing you can do in any letter when you're trying to ask for any type of accommodation from an employer is to admit things that could be, in fact, illegal.
Yeah.
And not all retaliation is illegal, although it's not wise. Retaliation is only illegal if it's retaliation for something that's protected. So, you might have a jerk boss, but the law doesn't protect you against the jerk boss. It will protect you against a boss who wants to fire you because you reported that he was sexually harassing you. Right? So that kind of retaliation is prohibited. In this particular instance, I can tell you that the claims of retaliation were claims of retaliation against a person for engaging in protected activity. So in this letter, she is essentially saying, well, I did retaliate, but other people have retaliated against me before. Or I've been harassed by coworkers. That's a bad idea. This is a bad idea, because what you're saying is, hey, I admit I've broke the law, but other people have too, and that's not essentially persuasive, and it also is a reason why an employer may not give you severance, because the Equal Employment Opportunity Commission, or the Utah Anti-Discrimination Labor Division, if one of those workers who was retaliated against made a claim against the employer, and the employer says, yeah, we concluded that this person was retaliated against by employee X who was fired, but we gave her a severance payment, the EEOC might say, oh, well, why did you give that person a severance payment when they broke the law? That doesn't seem to be a punishment, and it actually seems to encourage this type of behavior. So you got to think about that. Then the next paragraph, the person again makes a big mistake. On March 3rd, 2021, I was called into the HR office and asked about the retaliation efforts by my supervisor against my coworker. I answered these questions to the best of my ability and felt that things were improving between them. I also was not instructed to keep the conversation confidential and did speak with my supervisor, a person I trusted and should respect. So let's read between the lines there. The HR department was doing an investigation on whether this person's supervisor was retaliating against a coworker. She answered the questions and then went and told her supervisor that she was asked those questions, and claims that she was never told to keep it confidential and she should have told her supervisor. It's, again, a really bad idea.
Right. So she's kind of, throughout the letter, she's kind of building her highway to hell.
Right.
Because she keeps admitting to infractions.
Right. And essentially what she's trying to do is say, I was bad, but there are other people who are worse. Or, I was bad, but you didn't tell me this was bad. And that's like the next paragraph, if you want to read that.
I'm also accused of sending offending messages through the email system, which is a violation of employer policies. Not once during the 19 years working for employer have I received instruction or training on these procedures. I've never signed any documents to indicate my knowledge of these policies, or have I received supervisory guidance on proper email etiquette in the workplace.
So do you see what's happened there? She said...
Well, if I can guess, and then you tell me if I'm right or wrong. She's saying, I would read this as, oh, I've sent offensive messages, but you didn't tell me not to.
I wasn't trained, and I didn't sign anything that said I couldn't.
Right.
So again, not a super good idea. And then at the end, she says, okay, I expect severance.
Right.
So now you may think, come on, this seems ridiculous. Why would anyone ever think they were entitled to severance? I can tell you this person thought they should have severance. They thought they had been wronged. Okay?
Right.
And this is a little bit extreme, but a lot of the times when employees who are often, most of the time they're unrepresented, they do this kind of thing and they make huge mistakes. Well, one is they admit things they shouldn't admit. When trying to justify their behavior, they also make unfortunate admissions that could harm the employer if a lawsuit was brought against the employer for the behavior the employee is admitting to. And secondly, and thirdly, I should say, this letter, the tone of this letter is offensive.
Right.
And the tone is basically saying, you guys are wrong, even though I admit that I sent offensive emails, but you didn't tell me I shouldn't, and I don't know what email etiquette is.
Right.
I know you were doing an investigation to see if my supervisor was retaliating against my coworker, who, by the way, I admit I also retaliated against. And then I went and told the supervisor that you were asking questions about it. I mean, it's a super bad idea. So you would be surprised at how many people think it's a good idea to do this. Now, I am not saying.
Why do they think it's a good idea?
Because they think, like, as I started before, and I'm just putting myself into the mind of people who I've talked to a lot, is that they think that, first of all, they have the impression that because they've heard this over and over again, that if they feel like they have been harassed or wronged, that they're harassed, that's an actionable claim. But the fact is that in Utah and in most states in the union, you do not have the right to work in a jerk-free environment. You have the right to not be discriminated against. You have the right to not be treated differently because of your sex, age, sexual orientation, those sorts of things. You have that right, but you don't have the right to have your boss speak nicely to you. Now, that sounds kind of harsh, but it's true, and that's because Utah and most of the states in the union have adopted the idea that a free market solves those problems. And the free market says if a guy's a jerk, people aren't going to work for him, and therefore people will quit. They'll have a high turnover. It will be expensive, and that employer will not survive. However, we see all kinds of things on TV, on movies, where people, say, oh, I'm entitled to $50 million because somebody, was mean to me. And people believe that they have claims. They hear that they're in a hostile work environment, and they understand hostile work environment to mean jerk-free environment. And it doesn't mean that. It means a work environment free of hostility to you because of your race, sex, gender, sexual orientation, etc. It does not mean a workplace free of any hostility. It just doesn't. So when they send these letters, a lot of times they're thinking, well, I can show you how it's been hostile to me, even though I've been hostile back, and therefore you're in danger of having some kind of claim brought against you. Now, I'm not saying if you have legitimate claims that you shouldn't assert those claims, but there's also danger in writing that letter yourself and including some facts that could actually hurt you. It could also hurt your employer. And the fact is, in Utah, there is no individual liability for discrimination claims, for instance. If the supervisor, if your supervisor discriminates against you because you are an African American, you cannot sue that supervisor for that in Utah. You sue the employer for that. It's vicarious liability because the employer is the one that pays you, etc. So, because of that, sometimes what you say can hurt the employer, even though, like in this particular instance, when she said, well, I agree that I retaliate. Well, she didn't say I agree. She implied that she retaliated, but she was also responding to retaliation she'd received.
Right.
Well, just by admitting she retaliated, she's created liability for the employer potentially. And so that just undermines her claim for severance. So the next question seems to be, well, how do you solve that problem then? I mean, in this case, she gets fired. She's unhappy. She wants severance. What do you do? And for an employee in that position, I can tell you that most people have hearts. Most people are not Scrooge. They don't like letting people go, even if there's a good reason for it. A much better approach in this particular case would have been for her to say, I've worked for 19 years. I've relied on this job. I feel bad about the circumstances. Would you be willing to provide me a severance in this circumstance? That's a much better approach than this.
Right.
And the worst that they can say is no.
If you try, so it would be better, instead of trying to prove why you deserve a severance, to just ask for one?
Yes.
Yeah, it's interesting.
Unless, the best thing to do, of course, is go to a lawyer and have a lawyer evaluate it. A lawyer will sometimes send what's called a demand letter and say, well, rather than me bringing a claim, let's do this. Let's do the settlement, and we'll enter into a severance agreement as part of that. But that's a lawyer doing it.
Right.
That's a lawyer who's very careful and knows whether you have claims or not. But if you're unrepresented, it's much better to say, look, I feel bad about the circumstance. I've worked for you for 19 years. Look, it wasn't like I was terrible at my job. I got some awards. Would you be willing to give me severance? So that's probably a better approach than this, because this, what does the HR manager think? What does the employer think? Are they going, oh, well, she's right, I better pay her money? No.
Right.
They don't. However, if she had gone the other way and said this, they may have said, okay, we'll give you 2 weeks, we'll give you a month, something like that.
Okay.
But now there's another thing that I wanted to talk about with respect to this, and this is what not to say in a letter back to an offer of severance.
Okay.
Okay, so the situation we just talked about is where someone hasn't been offered severance and they're asking for severance. Well, what about the situation where an employer says, hey, this is part of a layoff. This is our standard package. Here you go. You've got 21 days, or over 40. You got 21 days to consider it. Let us know if you want it or not. Sign it if you do. Okay. So you've been given the offer. Now, remember, we've talked about in previous episodes too about what to negotiate. Well, you should negotiate those things, but there's a problem. There's a problem. Right. If you respond back in a particular way, you could lose the right to even the severance that was offered to you.
Mm.
They could say, oh, well, the severance is now off the table and we don't have to give it to you. And let me explain why that is. So under common law, and common law just means judge-made law, okay? In order to form a contract, there has to be an offer made, and then there has to be an acceptance of that offer, okay? So, example, I'll pay you $1,000 if you agree to mow my lawn for the next 3 months. Person says...
I'm trying to work out in my brain if that's a good deal. But sorry, keep going.
Person says, accepted. Okay? You have formed a contract. One person promises one thing, mow lawn 3 months. Another person accepts the offer, which was, you do that if you promise to pay me $1,000. that promise, consideration, the thing of value you give in exchange is called the consideration. So the I give you $1,000 as consideration for the mow the lawn for 3 months. Okay. That is a contract. But the common law requires this. You have to accept the offer exactly as given to you. Exactly. So, in that circumstance, I pay you $1,000 if you mow my lawn for the next 3 months. Your response is, make it 4 months, and you got a deal. And you say, nope. As soon as you said 4 months and you got a deal, that was a rejection of the original offer. And it dies. The offer dies.
Okay.
And you don't get to go back and say, oh, wait, no, I want the original deal. The law says no. Okay, so let's put that in the severance scenario. I'll give you, here's the severance package. Here you go. I look at it. I like the terms. I like the fact that they're paying me 3 months worth of salary. I'm willing to live with that because I already have another job I can go do.
Sure.
But I want them to waive claims against me. We talked about that. I'm going to waive my claims against them, but I want them to waive their claims against me. So I say, no, I won't accept that. I'll accept it if you waive your claims against me. What you just did was reject the severance agreement. It's off the table now. They don't have to offer it back to you.
Right. Okay.
So, you see a problem? If you say the wrong thing, you could lose the severance offer. It may be a good severance offer. It may be worth taking, but you still want to ask some things.
Right. So, okay. What do you say so that you don't lose it?
So the way to deal with it is to say, thank you for the offer. I'm not rejecting your offer, but I'm going to make some suggestions. Would you be willing to consider adding this? Again, I'm not rejecting your offer. I'm just suggesting that you add these provisions. By doing that, what you've done is not...
Well, hold on. Can't they just pull it back at any time anyway, if you haven't accepted it?
True. Okay. In most circumstances, if someone makes an offer, it's only open for as long as the offer is open for. So, but in most cases, severance offers have, because if you're waiving your rights under the Age Discrimination and Employment Act, you have to give an employee at least 21 days to consider. So it has to stay open for 21 days. Now, if you're not 40 and it's not Age Discrimination and Employment Act, it may not be open for 21 days. So, I mean, there is that issue, but for the most part, most severance agreements will have a time limit. If you're under that time limited exception, saying, hey, would you be willing to do X? I'm not rejecting this offer. I'm just wondering if you'd be willing to explore that. Then you've preserved your right to later accept the offer, even though they were unwilling to negotiate. Okay. On the other hand, if you said to them, I'm not going to accept it unless you do X and Y, you've rejected it. You have no right to ask them to give you the severance. Now, will most people allow you to still accept? Yes. 90% of the time. But there's still a chance they won't. Some people will play hardball. No, this is it. Unless you accept it, it's gone. If you don't accept it on the initial thing, I'm taking it away. So you have to be careful about how you approach negotiations when it's been offered to you. And never say, if you're willing to accept the offer they've provided to you, never say, this is okay with me, but why don't you add this? As soon as you do that, it's off the table now, and they don't have to give it back to you.
Okay. Well, that's all very good to know. There's a lot that you can do wrong.
Yes. And so, obviously, it's important to talk to a lawyer who knows what he or she is doing.
Right.
And it's worth the money if you have a good lawyer helping you, because you can avoid these huge pitfalls. I can't tell you how many times, James, that I've had people, like my employer clients, call me and say, oh, these people said they've got a lawyer and they're going to sue unless you give them X or Y. And how many times I've said, okay, let's see if they have a lawyer. Most of the time they don't. So the only thing about the letter I shared with you that's kind of unusual is she says, unless you give me an acceptable severance offer, I will seek counsel. Most people say they have, but they really haven't. Or what they meant by talking to a lawyer was they talked to the brother of somebody who was a lawyer who told them that the brother said, you know, X or Y. So it's worth it. It's worth it. It's worth it even to go to a lawyer just to evaluate the severance agreement to see if it's fair or not, or if it's standard or not.
Right. Yeah, because the provisions are worth, if you were to boil the provisions you can negotiate in them down to numbers, they'd be worth a lot. And the financial aspect could be worth a lot. So that makes sense.
Yeah.
Okay.
And the fact is, as I've described before, and I can't make any promises, but in negotiating severance for my clients, I'm often able to increase the amount they get. And I'm also able to negotiate more favorable terms with respect to non-competition agreements, mutual waivers, etc. And so it's worth the time. Usually you're going to actually pay the lawyer much less than the benefit that you're going to get.
Right.
Than the value of the benefit that you're going to get.
Right.
Yeah.
Okay. Well, thank you, Scott. This was good. It's our best episode so far.
Well, thank you.
We'll meet again soon to talk about more things related to severance and other common pitfalls that befall employees.
All right. Thank you, James. It's been fun.
Yes. A quick disclaimer, Scott is licensed only in Utah and Idaho. As with any discussion about the law, the information on this podcast generally describes the law and is not intended as specific legal advice. As I'm sure you know, laws frequently change and can be different in different jurisdictions. So please consult with a lawyer if you have specific questions. Fired Up is presented in audio format wherever you listen to podcasts and in video format on YouTube. Wherever you tune in, please remember to rate and subscribe to the show. Thank you.